This appeal is about discovery assessments by Her Majesty's Commissioners for Revenue and Customs. I'll call them the Revenue. In most cases now, tax is paid on the basis of the taxpayer's own calculation of what is due in their tax return. This is called a self-assessment. But if the Revenue thinks that the self-assessment is wrong, they may open an inquiry into the self-assessment and amend the assessment at the end of that inquiry by substituting the amount they consider to be correct. The taxpayer then has a right of appeal. The time limit for opening such an inquiry is 1 year from the date when the tax return is filed. But the Revenue are given further time to make a different assessment from that of the taxpayer if, among other things, the insufficiency of the earlier assessment has been brought about deliberately or carelessly by the taxpayer. This is called a discovery assessment because it depends upon an officer of the Revenue discovering the insufficiency. If the taxpayer has been careless, the Revenue have 6 years from the date of the year to which the assessment relates to make a discovery assessment. If the taxpayer has brought about the insufficiency deliberately, that time limit is extended to 20 years. The taxpayer, Mr. Tooth, filed a tax return early in 2009, in which he self-assessed his tax liability for the 2007-8 tax year. He did so on the basis of including a large artificial loss created by his use of a tax avoidance scheme in the 2008-9 year, which he claimed to be entitled to carry back to the 2007-8 year. He used an electronic form of tax return, which had built-in software approved by the Revenue, which calculated the tax due, provided that the taxpayer entered the relevant elements of the calculation in the right boxes. Unfortunately, a software defect prevented Mr. Tooth's tax advisors from entering the loss generated by the tax avoidance scheme in the right box. So, after consulting with the software engineers, they entered it in a different box, designed for partnership income, but explained exactly what they had done and why in an adjacent space called a white space, in which the taxpayers are encouraged to provide any further information necessary to make their tax return both correct and complete. The Revenue regarded Mr. Tooth's return as insufficient from the moment of its receipt. He was one of a number of taxpayers who had used that particular tax avoidance scheme, and the Revenue did not believe that it worked. But they did not at that stage open an appropriate inquiry into Mr. Tooth's return. They sought to protect their position in another way, which later turned out to be ineffective. It took until late 2013 for the Revenue to achieve final victory in the battle with Mr. Tooth and others about the ineffectiveness of the tax avoidance scheme. In October 2014, the officer in the Revenue newly responsible for Mr. Tooth's file then made a discovery assessment, cancelling out his claimed losses on the basis that the insufficiency in Mr. Tooth's self-assessment had been brought about by him or his advisors deliberately. They relied on a provision in the legislation which says that an insufficiency is deemed to have been brought about deliberately if it is the result of, quotes, a deliberate inaccuracy in a document given to the Revenue, quotes off. Putting the loss generated by the scheme in the wrong box in the tax return was, the Revenue claimed, both deliberate and inaccurate, even though the Revenue accepted that Mr. Tooth genuinely believed that the amount of his self-assessment was correct. Mr. Tooth appealed the discovery assessment. First, he said that, bearing in mind that he had explained in the available white space what he had been forced to do in the electronic tax return, there was no deliberate inaccuracy in the tax return. I will call that the inaccuracy point. Secondly, he said that there had been no discovery of the insufficiency in 2014 because the Revenue had known all about it since 2009. I will call that the discovery point. He won on the inaccuracy point before the first-tier tribunal. He won on both points before the upper tribunal. In the Court of Appeal, he lost on the inaccuracy point, but won on the discovery point. But the result was that he was successful at all three levels, so the Revenue has appealed to this court. We unanimously dismiss the Revenue's appeal. Lord Sales and I give a joint judgment, with which Lord Reid, Lord Leggett and Lord Burrows all agree. Our conclusion is substantially the same as that of the first-tier tribunal, namely that there was a relevant discovery, but that Mr. Tooth's return was neither inaccurate nor deliberately so. Our reasons are in summary as follows. A tax return, like any other document, is to be read as a whole, and statements made in it interpreted in their context as parts of the whole document. The fact that electronic tax returns are machine-read on arrival at the revenue, and that computers may not be able to do contextual interpretation, is neither here nor there. In the present case, the full explanation for Mr. Tooth's inability to put his scheme-generated loss in the appropriate box in the electronic tax return was fully explained in the adjacent white space, so that no human reader could have been misled as to its intended meaning. The tax return was simply not inaccurate, read as a whole, rather than read with the tunnel vision of a computer, looking separately at each box in the return, while ignoring the rest of the document. But further than that, the evident care with which Mr. Tooth's advisors explained what they had done demonstrated that there had been no intent to mislead the revenue. A deliberate inaccuracy is a statement that is intended to mislead, not merely a statement intentionally made that happens to be inaccurate, as the revenue argued. But the fact that the revenue may generally be said to have known from 2009 that there was an insufficiency in Mr. Tooth's tax return does not mean that the officer who decided to make the assessment in 2014 did not discover the insufficiency. He was new to Mr. Tooth's file in 2014, and it is his discovery, not some earlier discovery by someone else in the revenue, that matters. The legislation about discovery assessments is careful in focusing the discovery question on the officer who decides to make the assessment. Discovery requires the officer to have more than a mere suspicion of insufficiency, and therefore protects the taxpayer from merely speculative assessments outside the one-year inquiry period. But the taxpayer needs no protection from stale discoveries, as had previously been thought. The taxpayer is protected by time limits of 4, 6, and 20 years for discovery assessments, all of which run from the date of the relevant tax year, not from the date of the discovery.